So what we're seeing across the globe today is a situation where privacy is at the heart of internet policy, whether it is regulation of large global behemoths or looking to protect citizens' rights. Governments are moving in to create data protection laws and to protect citizens' rights, especially with respect to how companies are collecting data. We have a situation in India where about 3 years ago, no one used to talk about privacy, but that debate has began with a challenge on the fundamental right to privacy, whether it exists in India or not, and it escalated where privacy was declared as a fundamental right, and eventually we now have a process in play where we might get a data protection bill. Discussions have been on in India with various consultations, starting with the Sri Krishna Committee and then at MeitY, on what the contours of a data protection bill in India should be. This is now at the Joint Parliamentary Committee level, and we hope that within a year we will get a data protection law. To discuss his views on privacy, we have Mr. Amar Patnaik, a member of the Joint Parliamentary Committee, with us. I think what we all want is an improvement in the protection of citizen rights, but also creating an environment of trust where usage of data, usage of the internet doesn't suffer because either the governments don't trust citizens, or citizens don't trust governments, or citizens don't trust companies, or companies don't trust each other. So wanted to discuss with you some contours of privacy and what can be done to improve trust in the internet, especially with the perspective of privacy. So firstly, sir, I wanted to check with you about what your views are on what the data protection authority should be like, because that's going to be the primary controller or regulator for data protection in the country. So what should the role of the DPA be?
You see, first thing I'll address is what you talked about is trust. If you look at the preamble to the bill, I think it talks about trust between the citizen and the data issued. You see, who is the, in my opinion, you would agree that the largest user of internet is the citizen actually. Governments and companies taken together, it is still the citizens who want that internet. They should trust that whatever they are doing on the internet is not going to be acting detrimental or harm them in some way or the other. And therefore the flow, their information has to be safeguarded, their privacy has to be respected, and then this entire thing flows about data protection. The data protection authority that the bill prescribes, there have been arguments, and since I'm in the committee, it's evolving, how the discussions are evolving, how the Sri Krishna Committee's, the current bill is departing from the Sri Krishna Committee's recommendations in certain aspects. But when we discuss the data protection authority, the structure itself is not unique, as there are many places in the world. But the composition and the power to declare certain things as sensitive and critical sensitive, whole lot of responsibility is given to this authority. So a lot of how the act spreads out, how this ecosystem of data protection, privacy, affecting economy, and also simultaneously balancing individuals' privacy will depend on how these people are selected and manning the DBA. On that, I would probably, my personal view is that the bill could probably have done a better job of it, in the sense that the selection of the people who would be there in this is still amorphous. Who are the people who could be there? The usual lines that is written in selection of people and all these regulators, they should be from law background or administration, whole lot of things is usually written in any kind of authorities things. So that will not apply here. I think the people who should be manning the DBA is very important. They should be from cross-section of the users of internet, which should be citizens or citizen representative citizens through various organizations, the companies themselves, the government officials. I personally feel that there is an over dependence on the government officials deciding how this should pan out by being a part of the Data Protection Authority, which is, I think, not really right. So this is what is my personal view, and probably this could be the view of other members and all. We'll see how it comes out.
So one thing you mentioned was that the DPA itself has too many government members, but that hasn't been specified. And the selection commission that will decide who becomes a part of the DPA is now largely bureaucratic. Do you think that's the way to go forward, or was the previous version?
Where there was a member of the judiciary as well.
Yes.
a part
So
of
I
the
say that the over dependence on government officials,
Right.
people who have probably, what has happened in India usually is that the people who have drafted a certain bill initially,
Yes.
they become finally the first person to man that authority or that regulator position, which is really not good, because there could be an argument which says that this will be a seamless what is a broadening or regulation of the ecosystem as per the bill, but I really don't agree on that, because what happens is that you are having a lot of baggage and you are just bringing it down to the authority, and all the stakeholders are not taken into board. When you are interacting with a whole lot of stakeholders already before making the bill, I think you should have, we should be able to, the JPC should be able to say that these are the kind of people who should be in the Data Protection Authority, and the government should accept that.
So what about the structure of the
Yes.
DPA? Because there's one, I mean, in our discussions, one of the things, suggestions that we heard was that there needs to be a separation between the rule-making role of the DPA and the adjudicating role, which may be better placed with an ombudsman, but also that the DPA might also want to create advisory groups of independent experts instead of having all of these a part of a single body as such.
So I say this, when I go through the bill, and my concerns are shared by many others as well, that a number of things in the bill has been left to be decided by the central government later.
Yes.
So it is as good as not having the bill itself. I think one of the members did mention that if you're talking that everything will come up in the rules, why don't you bring them here in the act itself and put it there itself? Because you can't leave everything to be decided by the central government, in which case we go back to square one, where we started. We are just meeting the conditions for the purpose of meeting the Supreme Court's directions of having some kind of a legislation, but it is not worth the paper on which it is written. So the point is, I do agree that since the Data Protection Authority would be the overarching authority for managing this entire the data protection privacy issues in our country, how it should be manned, what is the way in which they should be selected, because you see, each of the members, let us say he's from the judiciary. Judiciary is huge itself. Who should be in the judiciary? Who should be occupying that position? In India, generally it has been held that the Supreme Court will nominate a name, and who would be that a person who would have just retired recently from the Supreme Court to the High Court. I think that shouldn't be the criteria. What should be important is someone who takes interest in this, who has a fair amount of idea about the gamut of data and how data flows are happening, how data flows are affecting economy of this country or economy elsewhere. And that should emerge, because as I said, ultimately the biggest user is the citizen. So the citizen should have some kind of a role in the appointment process, or even becoming a part of the Data Protection Authority. How it should work out, what kind of structure should work out, how the citizens should get represented over there, because citizen is huge anyway. That would have to be seen actually very carefully. Currently, we are not really haven't gone clause by clause in the JPC. So once that comes up, I think that discussion will come up. But personally, I think that since it is very critical to the entire data protection bill, the structure, the appointment process, what is the kind of deliberation, as you talked about rules, they couldn't be also making the rules themselves. I think we should have a fair amount of idea about how the rules would be, which will be in alignment with the objective that you are trying to achieve through the bill. Because if later they make rules which are inconsistent probably with some of the provisions of the Act, it will again land up in the courts. Some members do feel that instead of relegating a number of things to be decided later, some of it should actually come up on the table itself in the JTC.
Okay.
So what should the role of the government be with respect to the DPA? In the sense, we've seen a fair amount of interplay between regulators and the government. I mean, the RBI used to be typically at an arm's distance from the government. The TRAI, when it began, was fairly adversarial with the government. I'll give you an example of the Philippines, the DPA there, where the DPA actually recommended prosecution of the election commissioner in the Philippines because of leakage of data by the election commission there. But the government, because they didn't have any powers to actually prosecute, the government never executed on that recommendation. So I'm just curious from a practical perspective, what should there, do you expect that there should be an adversarial role between the DPA and the government, or should there be close coordination, or I mean, what's the ideal situation from a citizen's perspective?
See, as you said, all regulators are supposed to be at arm's length from the government and from the executive of the day, or executive as in general. But you see, their budgets, they are finally coming from the finance department.
Right.
So there are several ways in which they exercise control over the functioning of the regulator. Unless you are a constitutional authority like the CAG or the Chief Election Commissioner, where they have real independence, the statutory authorities or statutory bodies like the Data Protection Authority or CVC or CIC, or they are constrained to a large extent, and their functioning can really be manipulated by the executive of the day. Whereas for a constitutional authority, it will require amendments in the constitution itself, which is a much tougher process. So statutory authorities, giving statutory responsibility, the powers which are given by a statute can also be withdrawn from by a very simple process in the legislature, which is much more difficult for a constitutional authority. So I think a situation may be there in which people have to debate whether this data protection authority should have there should be an amendment in the constitution to have a constitutional role for it rather than the statutory role for it, in which case government's interference can be there, is there, and would be there probably in future. So, and this is a larger issue, this is my personal opinion. But since this is so key to a number of things, and the interplay with other regulators would also be to a large extent handled by this authority, one has to see how this arm's length approach can be adopted here, because any statutory authority in India really doesn't have complete kind of independence as is there with these constitutional authorities.
Are there means of creating financial independence, even without having it deemed as a constitutional authority?
Yeah, there is a provision of getting, you get charges, you get, TRI has a revenue mobilization effort of its own by issuing licenses, whatever they get money. That could be there, there, but as I said, a statute is a statute which can be changed in the legislature. But if it is a provision in the constitution, you can't change it. I'm not talking about even the basic structure, I'm just talking about even minor changes in the constitution would require a larger rigor in getting it cleared from the parliament and from the state, every state of this country. Since this is something which is going to affect the entire country as a whole, every state, everywhere, different states may have different requirements of state governments' access to the personal data of individuals. It is very important that, since the Data Protection Authority is going to be the crux of this entire thing, they are the pillar of this bill, we have to think about a role for them, or ensure their independence, not just financial. Financial is very important, but besides financial, you pass an order which nobody carries out. So the execution power is not there, then it is of no use. So that has to be thought about quite a bit. Very frankly, I feel that statutory regulators who have been created, they are they sometimes the governments can change their behavior, influence their behavior, influence their decisions much more easily than a constitutional authority.
So do you think, we talked about the structure of the DPA, expanding the size of the DPA itself would be useful, because right now it's just 6 full-time members,
Yes.
and part-time members
This
aren't
is
allowed.
not more than 6.
Yes, not more than 6. So, and part-time members aren't allowed, but independent experts can be hired, or can be commissioned rather. So do you think expanding the size and having a federated structure to the DPA would help, like having zonal offices or state level offices where there's
That's what I feel, the consultation on this bill with the federal structures, because you see the information that is being generated of individuals, a large amount of that information is not just kept by the central government, they are also kept by the federal state government, and more importantly by the local municipalities and panchayat raj institutions. A huge amount of information is there. And those people who are at the ground, living in villages, they probably are not really aware of this bill and their privacy and all that. But a time will come when that will become that will be central to how things are administered for them in terms of giving them various kinds of benefits, but also to design different things. Now, we can't think of anything in our country or anywhere else for that matter, remaining completely divorced from the political economy of the place, or of the region, or of the state, or of the country as a whole. So there are different kind of people using that data at the village level, at the rural level, at the block level. I don't think there is enough consultation which has happened with the states on this particular issue.
With the states themselves?
With the states themselves.
Okay.
Or because the stakeholders here, it's actually a great work which is being done by the civil society for spreading the message about this and carrying out discussions, finding out discussions, what is happening. But what is the view of the people? Because I told you, the person who is going to be affected the most is the citizen here. And the citizens don't live in only the cities and in the towns and the big towns and all. It will be also in the villages, in the municipal corporations and the small municipalities. How they are going to look at it, I do not think that kind of consultation has been done. We are doing it in too much of a hurry.
There's also the issue of the cost to the citizen, in the sense that if the DPA is going to be based in Delhi, then they're largely going to be inaccessible to someone whose rights.
But the
may be
Act doesn't really say that. The Act
Right.
doesn't say that there will be only one DBA at Delhi.
Right.
It could actually be in every state, like the
it's-
RTI, the CIC
only
was
6
a central
members.
bill, but then every
Right.
state started having it.
But,
But,
it's only
yeah.
6 members, sir, so it's likely to be in one place rather than 6
Have-
members spread across the country.
No, but the point is that every state can actually have a separate rule and have constitute it. I think that should be, because it's not possible to do the entire administration or the number of interpretation issues that would come up by one body which is just having 6 members.
And given how our data is dealt with today,
yeah.
the volume of complaints is likely to incapacitate any
And
body.
more importantly, I think to that extent, probably I would agree with her that if you have more number of people, then there is a chance of the group thing not kicking in actually. Because if you have very small number of people, then the group thing happens that okay, we like all agree to something. But if there are a large number of people, there's scope for dissent, scope for not
Right.
agreeing to something. In which case, a much more kind of considered view of a subject of an issue can be taken. So to that extent, I agree. But I have a gut feeling that this will have to be set up at different places, because every state's requirement of data and how the data of citizens should be used would probably not be the same.
So just zooming out and looking at it from a more philosophical perspective, do you think that there should have been, like, the discussion on privacy and the bill is both looking at things both from a privacy perspective as well as as the economics of data perspective? Do you think that there's a conflict in those two? Should the bill have been focused purely on protecting citizens' privacy?
You see, let's go to the fundamental of this bill, which is flowing out of one of the fundamental rights, which is enshrined in the Constitution. the fundamental rights, the 8 fundamental rights in the Constitution, they have been there since independence, since the writing of the Constitution. And still we have grown and we have flourished, our economy has grown, and whatever 8%, whatever has happened, country is growing, the GDP is growing, the per capita income is growing. So despite the fundamental rights of citizens being at the core of governance in this country, and citizens' fundamental rights being inviolable, the country has grown. So I don't think that if you have a very robust privacy law, the country cannot grow. So the argument which is probably made by some of the government authorities that if you are too stuck up on the privacy of the individual, then business cannot grow and
Yes.
GDP cannot grow, that just falls flat, because the courts have so strenuously and strongly protected the individual's fundamental rights, in which privacy is a part now, as interpreted by the Constitution, and still this country has grown and grown well. I therefore feel that the overarching thing in this, the executive or the central government or anybody anybody in government should kind of keep in mind and be cognizant of, is the fact that you can still have strong privacy laws, consent-based, completely consent-based, and will not be a hindrance to economic growth or giving services to people.
On the question of consent, how does consent then work with respect to the government? Because government agencies are defined as data fiduciaries under the bill. So they would also need consent of individuals, right? So then how would government access to data, especially of law enforcement agencies, work?
No. As I said, we still have the fundamental rights and we still have a very robust judicial system and a legal system. If we are having a provision which says that, again, flowing out of a fundamental right, that within a person who has been arrested has to be produced before a court of law within 24 hours, does it mean that this has led to a kind of anarchism and lawlessness in this country? No. It has balanced the individual's right to be heard in a judicial system, in a robust judicial system, and at the same time given power to the executive to nab that fellow who was probably perpetrated a crime and produce it in the court. The government cannot decide for itself that this is the crime and I am the judge who will decide that this is wrong. So that beautiful system has evolved in India, and I think we should put that in the perspective. So if the government wants to get data and has used it, then probably we'll have to have a mechanism in which it is announced to or it is told to the citizen within 24 hours that this is what we have done, and the Data Protection Authority then decides whether it is right or wrong, and if it feels that it is wrong, it is again withdrawn.
So should there be restrictions?
We have to, that is what I am saying in this law as it is so far. A lot of it has been left to be decided later.
Right.
And I think these things will probably come up later. The structure of only the structure is there in the bill. A lot of the details are still not there.
So the Puttaswamy judgment particularly specified that when there's government access to data, it should be necessary and proportionate. And also, from what I remember, it called for surveillance reform, which the Sri Krishna committee, when it was creating the bill,
I know what you're getting at. You're trying to say that the broad principles have been set out, but then the finer details has to come out, which is not there.
No, sir. If you look at the Sri Krishna bill and you look at this bill, that bit about proportionality and restrictions, or some semblance of control over what the government can and cannot access, was there. In this one, that's been completely removed. Do you think that will
No,
hold?
I hold my
right?
view that this has to be thought about, because the theory or the notion that if you are placing too much of importance on the privacy of citizens, it will affect governance. I think I don't buy that.
This is in fact something that the Delhi police, at least a representative in conversation with us, had said that that's one of the changes that they wanted, because for them to investigate crimes, if there are restrictions, then that impedes their ability to investigate.
No, but the bill is very clear. Once again, as I say that even now, whatever the investigations are taking place, for crime control, fraud control, or whatever, many of those things. Currently, they are under the very robust judicial system that we have. If we feel, if at some point of time the government's actions or the criminal or investigative agency's action is found to be disproportionate, then the access to the court is there, and he gets a stay or he does whatever is possible. In this particular, so that the broad framework which has been set up by the Supreme Court is in line with the overall ecosystem of our jurisprudence in this country, both criminal as well as civil, everything taken together. Now the data breaches that will take place currently, I think the emphasis is on, again going back to the judicial system and taking care and being under this jurisprudence to seek relief, whether through a fine and getting a stay on the fine. So the investigating agencies' power to access that data was there and should be there, but there should be controls on it.
Do you think that
so who are the agencies who should get it? How much they should get it? If they do get it, who should they inform? How quickly they should inform? So that the person whose information has been taken, because he's a suspect, but his access to the judicial system cannot be denied.
Right.
Should this be?
But he should not know for a month that his data is being used, and he doesn't know about it.
Right.
So there might be circumstances, especially in case of activities of anti-national elements like terrorists, for example, where that might be necessary to surveil them over a period of time.
Surveillance is fine. Surveillance is fine. Surveillance is fine, but for the purpose of, in fact, the courts have said that you have to come out with a surveillance law.
Right.
We don't have that.
Do you think this law was an opportunity to do that, or should there be a separate law for surveillance reform?
I don't think it stops the government from coming out with another one.
It doesn't, but do you think this was an opportunity where they could have done that?
That opportunity is not lost really. They could actually come out.
Okay. So I'm just wondering about we have seen the usage of facial recognition technology, and for example, there's a company called Clearview AI, which it seems has done a pilot with the Vadodara police, and there is a rollout of CCTVs of police taking videos, especially we saw recently during the protests in Delhi that the police was recording information. Do you think that there might be a need for restriction on without consent, the police taking videos?
Yeah, but the point in this case, or largely, what is the public interest or general interest of the citizenry, or the country that is India as a whole? What is good for that? So I think that ultimately also when the Supreme Court or the other courts interpret, when somebody goes to them, they will interpret what is there in the interest of the larger public. What is larger public good. In this case, if the citizens' photographs are being taken, and there's still a gray area, because if you see when Yogi Adityanath has put those photographs on the streets, then the High Court has stated who asked you to do it. Even the Supreme Court's oral observation has been that, though it's being tested now, it was gone to a three-judge bench. So I think finally the things will emerge as to how far the police can go and how far the police will not go. But my personal opinion is that in such cases such as this, which is in the interest of larger public good, the investigating agencies or the government should be able to do some things which ordinarily it should not be allowed to do.
So the Supreme Court in a few cases has categorically said that terms such as public order and public interest need to be narrowly defined.
Correct.
Which is something that this bill
does
not.
Hasn't. It has just left it like that.
Yes.
And for interpretation.
Yes.
So I said, repeating it,
right.
At the cost of repetition, I'd say that the bills leave a lot of very subjective, general kind of statements in the drafting, and needs to be very, very specific in a number of areas, particularly relating to exemptions, particularly relating to 91, what is good for digital economy,
right.
What is public service,
right.
what is the kind of benefit. Now everything can be considered as benefit, the electricity that we get is also a benefit, but what would be considered as a benefit and for which what kind of data has to be used. The argument of the government could probably be that There are so many things. This is a large country. It spans a huge number of schemes. The way citizens are interacting with the government through a huge number of policy prescriptions and directions. Therefore, the Data Protection Authority should be able to do it. But I think the broad contour of it has to be put into the bill. I think that's probably unanimously held view of many of the my colleagues, MPs, both inside and outside the JPC.
So before we move on to a discussion about digital economy and non-personal data, you mentioned that access to courts is still guaranteed under the bill.
Yes.
But there's one section as per which only the DPA can approach the courts for any of the tenets related to the bill.
Yes, we've seen that. But
So,
you see, access to the justice system is basic to our constitution,
right.
basic to our democracy. No bill or act passed by the legislature can take away that. If it is there, it will be struck down.
It will be
Which is what happened with the Aadhaar Act
yes.
as well.
Yeah.
Okay.
So, and since now I think we can move to a discussion about digital economy, and as you mentioned that things such as public benefit, evidence-based policy potentially as well need to be clearly defined. So,
You know, there is a school in Harvard, Kennedy
Yes.
School,
yes,
which does evidence-based research.
right.
Right? They have been invited by Niti Aayog just 2 years ago to make our policy more evidence-based, which basically means our policy in India was not evidence-based for so long. A huge number of policies are decided without having a lot of evidence, a lot of data coming in. That has been traditionally our thing. That is, I'm not saying it's a good thing, but that's the way it was, for which data was not being collected, maybe because the size of the country was so huge, population size was so huge, representative samples were probably not taken, or maybe because once again, the legacy that we have, we know what's good, paternalistic, we know this broadly is good for you, so no data is required, even though the data, if actually collected, might point to something else different. Now, when that is not there, you do not know that half of your policies are 30%, 40% of your policies are more, I really don't know, are not evidence-based. To mention that in that particular clause in section 91, to say that for evidence-based policy making, we will have access to all data and will not have any consent, it just makes no sense, to just putting in, doing some kind of a cut and paste, taking it from somewhere and putting it there. And when things are not defined properly, that gives a lot of discretion to the government, which is what would impinge on the privacy of the citizen. So that's what I think is the bone of contention, that particular clause, that entire thing, with number of, it's a concern cutting across party lines, cutting across stakeholder lines, I would say.
So in fact, what we couldn't understand was why a non-personal data clause is a part of a personal data protection bill, especially when there's a committee that's already looking into it that might recommend a separate law for it. But do you just philosophically feel that the government should have access to data collected on the behavioral patterns, etc., of citizens by private entities for the purpose of their business? Do you think philosophically the government should get access to it?
I really didn't understand why the non-personal data clause was there in the personal data protection bill. Haven't really heard from Meiti on this so far. As I said, we haven't gone really clause by clause. But currently, as we discuss about the world over, talking about behavioral economics, influencing policy and how to design policy depending on behavior of individuals, citizens. Probably there is a role. It's a good thing if it happens. That is collecting the behavior of individuals and then designing a policy for that purpose, so that the benefit goes to the citizens in a more targeted manner and in a much more much better. Even again, it's actually deviating from the paternalistic kind of a thing, that policy from top down. It actually comes from bottom up. But I really don't know if that is the intention for which that particular provision is there, or that is how it is there. It could be something else. And to collect it from others, you see, sometimes the objective for which the behavioral pattern of in the citizens is collected by a company or by somebody who is doing it for a purpose is very different from the purpose for which that data would be required by the government. Whether the citizens' behavior or the reaction to a stimulus is different depending on the context in which that stimulus is given. Uh, I told you, the drafting of the bill and all that appears to me to be too hasty, and it's just some putting together a number of things and putting it together and making it into a bill and introducing it just to meet the Supreme Court's guidance on this issue. But I really think a lot more consultation was probably required.
So actually, it's to my mind, it comes from this change in philosophy in the government, especially when they were looking at Aadhaar, around viewing the state as a service provider, state as a platform. And so to that end, the propensity to collect more data, to use more data, and to use it as a mechanism for delivery of services comes in.
If that was the intention, it is probably good.
Because you're coming with a mindset of being similar to a Google or a Facebook or an Amazon, and so because you want to deliver services better, you
personally,
personally,
since I was also in the bureaucracy, we have been having the census data, which is the largest collection of data anywhere in the world.
Right.
Yes.
The census data collection, the ambit has been expanded. The kind of data that we keep on collecting has actually increased over a period of time. I know for certain that the entire amount of census data itself is not analyzed while making policies. To collect more amount of information in the name of giving better service, I really do not understand whether there is actually a felt need at the government level for better policy making, or it is only a ruse to get at the data of the individual.
So do you think there should be specificity in terms of specific conditions under which the government may get access to the data?
I fully agree on that. I've said that. It's too general, too non-specific, too subjective. At least the illustrative purposes for which it could be done. This is the point. When you are making a legislation which is not rule-based or a principle-based, you will have difficulty in making that bill, because the specifics could be several, could be many, and it cannot all be visualized from beforehand and kept in the bill. But if you make it a principle-based or a rule-based kind of a system, that's a proportionality rule or reasonableness rule or necessity rule, then what happens is that it can be evaluated whether a particular information is required and is fitting to this particular principle and rule, and then therefore should be accessed without consent or with the consent. Since this bill has not been made in that particular manner, this problem is there. And if we tell government or the people who have made the bill that you specify it by writing all the possibilities, it is going to be a thick one, and probably still something would be left out. Whereas if it is principle-based or rule-based, then you can actually follow those principles, and then the courts also, it will be easy for them to interpret it, because whether that principle has been followed or not.
Right. So in the case of sharing, data sharing of non-personal data, this bill now has only one offense, which is re-identification of data. So perhaps the situation that needs to be considered is what happens if the government is responsible for re-identification of data that it got from private companies. Will the government bear responsibility, and do you think there should be certain checks and balances defined in case non-personal data remains in the bill?
Certainly there should be checks and balances. Government is an entity which has no identity. It is too big, but the person who is responsible, an officer who would be responsible, why shouldn't he be held responsible or accountable for it?
Right, which is something that the bill also provides for. Right. Okay.
Bill provides for it.
Yes. So, and when it comes to data sharing, especially non-personal data, where private companies would be using their proprietary algorithms, do you think it will have, if this kind of access is mandated, it will have an impact on the intellectual property regime in India and how the world at large views us? Because a lot of the algorithms...
We have to be very clear on this. I've been going through this bill several times to realize that one mistake I think this bill is at a very conceptual level is not able to bring in is the distinction between data and information. I think that is what the problem is. It talks about a data protection bill, and the first preamble talks about data, but the next line talks about informational privacy.
Right.
It's actually data privacy.
Right.
And after the data, if you're using algorithms, you're using analytics to derive information, which will probably give rise to innovation, give rise to economy, things happening and all that. I think we should promote that particular thing. In fact, we should probably have a cost to it in the sense if someone is using that, needing that particular, if you can use that data to have a wide variety of information which could be benefiting the citizens or business as such, we should promote that. And government should not actually be calling for information, rather should be calling for data. What is your take on this?
So I'm actually I'm not very clear on the differentiation between data and information. That's it.
Data and information, processed data is information.
Right. So
data point, which are raw data,
but
need not necessarily be.
But raw data is an oxymoron, as has been established.
No, why? You get suppose the car numbers of people.
Yes.
You car numbers of people, and you want to check. Let us say you use analytics to find out that in this country, people are preferring small-sized car rather than big-sized car, and that information, and it is spatially different. Like in eastern part of India, there are smaller cars, from western bigger cars. So if someone sets up a factory, instead of setting up a big car factory in eastern part, it is better to set up in eastern. If this information is available and is given, what is wrong in it?
well, so if I'm a company that has that kind of information, I would treat that as proprietary and then look. Monetizing it would be my choice.
Good, yeah,
that
that's what I'm just saying that the government shouldn't be asking for it.
But the government
Right.
also can't.
No, I said that.
Yeah,
I said
yes.
that.
But the government also can't force me
I
to
said
monetize
government
that
should be asking for
information.
data. I said that.
Yes.
I said
Right.
government should be only asking for data, not for information.
Yes. But that inferred data, by the way, is also a part of the definition of personal data, and that's one change that's happened.
I know about that. I know about it. I told you that.
Yes.
That in the bill, this distinction between data and information is just not there. But in the scientific world, or even the non-scientific world, data and information are different completely. Data without analysis is of no use actually.
So we also have a situation right now where the government is actually selling our personal data. So in case of the Vahan and the Sathi database, we actually filed an RTI and gleaned that 147 companies had bought that data from the government.
Okay, now just tell me one thing. If people say that data is the new oil and oil is actually not sold for free anywhere, I do not know, this bill doesn't talk about it, but I would love to see a framework in which data is actually monetized and sold for the purpose of innovation, for the purpose of growth in economy. But for that kind of thing, I think it is the information, metadata, that will be more important rather than the raw data.
I look at it from a different framework. So I look at it from the perspective of data being a toxic asset, and the cost and the harms of the data being lost, or being manipulated, or being used against us potentially is much greater than the benefit of actually monetizing that data.
You know, whether we like it or not, data is going to be there. It's an asset which is there.
I agree.
If you're calling it as toxic,
No, but
then we have to manage the toxicity.
in that sense,
but data is going to be there.
No, but so from that perspective, what we need to do, if you view it as a toxic asset, then and you view it something that is being used against citizens, then philosophically there is a need for data disarmament globally. We know that there is a global market failure in privacy, in data protection. Our data has been, more data and more profiling has happened from a citizens' rights perspective that has been collected about us, and it has been weaponized against us and the countries that we inhabit in that sense. So I would say that one might say that we've lost that battle, that cat is out of the bag, but if you treat it as a toxic asset, then you start following principles of data minimization, of better anonymization, of using this to protect rather than using it to monetize. I would, like you also said, privacy can be seen as an economic good because it enables an environment of trust. The fact that our data is not being used against us allows us to be in a position to give more data. The fact that data usage is minimized also allows us, to engage more in economic activity. And you saw what happened with Facebook. People started signing off when the initial Cambridge Analytica situation came up. We saw that when the NSO hack became public and significant, some people started shifting from WhatsApp to Signal because the sense of privacy and sense of lower data collection was greater in Signal. So people want to give less data. It's just that I don't think they have that choice right now.
Okay, let's look at it from a purely conceptual level. We have assets, physical assets, buildings, roads, whatever, we have assets. Assets are also stolen. There is theft of assets. There are people come and have false documentation. Someone, your own building has been taken away or sold by somebody to somebody else. All these are there. But that doesn't mean that we as a nation or anywhere in the world, in the world as citizens or as individuals have foregone or would like that our ability to acquire assets, keep it with us, and trade with the assets whenever required, and safeguard our assets is going to be given up. No citizen would want it.
Absolutely.
So let us take a look at data also as an asset. There will be thefts. There will be misuse of data. There would be whatever. So the point here would be to put safeguards, to develop that market of data flow, to develop it in a manner that it is transparent and there are adequate safeguards to protect both the interest of the buyer and the seller kind of a stuff. So we must look at it that way and not look at it as a completely minimization and toxic asset. If we some people, at a spiritual level, people say, oh, you don't have assets, you shouldn't actually have as many assets because that gives you problem in the mind because your peace of mind is lost because you're managing too many assets. Right. That's a different level altogether. But if you look at it purely market economics, then I think the best way the data can be protected actually is to develop a market. Unless there is a value to something, people don't respect it.
So I started off by saying that there's a market failure in privacy and data protection.
So whenever there is, so even in normal asset, non-data based assets also there is market failure. And whenever there is market failure, government regulation should actually kick in and should actually be taking care of it. When there is government failure, what happens? Which has happened many times over. Now the debate is community should look after it. In the social space, they are saying that. In some places, they are saying that again market should be redesigned and you come back to it. That debate will continue. But I think to treat this asset as a toxic asset may not be right.
Because it will require a completely different framework for looking at it, which is that you might, for example, you might need nuclear fuel, but you treat it with more care. You realize that
so
it has.
I said that the safeguards have to be there. The level of safeguards could be different. The cost of safeguards could be higher. The regulation has to be more stringent.
The cost of violation could be higher.
The cost of violations could be high. The market development or the market for it could be developed in a much more rational and maybe at a pace which is little slower than the other assets. But I am strongly of the view that we should, as long as we do not treat data with a value, people will not respect their own data. But if I know that I have a data which has the potential in the market of let's say 1 lakh rupees, I will safeguard it. So when I give my consent, I'll be careful as well.
So
when I sign a lease deed agreement for my property, I check every word of it. But if there was available for free or at a price which is much less than what the market price is, then I would probably agree to it immediately.
So one of the things that came up in the Supreme Court case was this idea of informational self-determination. And I think there was also discussions about whether data should be seen as property and purely as an asset for trading. And that's why it got privacy was accorded the status of a right or recognized as a right already enshrined in Article 21 and 14. And so I'm just, it can't purely be seen as an asset either. It's a right too.
No, no, that's right. You are right on that as well. But my reaction was to your statement that it is
About
a toxic
toxic asset.
asset. So you're
Right.
treating it as an asset. So it is much beyond assets. As an asset class which has to be only monetized and sold, it is something which is required for the growth of the individual itself, both in terms of his own personal growth as well as growth which is determined by the government of the day. And also to ensure that he is able to exercise his rights as an individual in different fora, to whether in the judiciary and the legislature, or to even for his self growth. For his self growth, why do we only think about data as something which is to be traded between the government and the citizen? It could be between citizen classes themselves, which might lead to the growth of the citizen himself if he is doing it properly. So we have to develop that particular thing, and those are things which I find in the Supreme Court's judgment so pregnant with these principles, these rules, these thoughts, which has not been actually translated into
Right.
this law, into this bill, which they are trying to make it into a law.
So in that context, how do you view data localization? And do you think that we
Data
need to-
localization, they have said, is only for critical sensitive data, critical sensitive personal data.
Yes. And critical personal data.
Now,
has
whether
been-
technologically in this world it is possible, something I have my own views. If someone wants to do it, that is only storing part possible. But if you say that we will process, those data cannot be processed outside India, I really don't know, because it's very easy to prescribe public policy, but if you cannot implement it, then there is then automatically there are rent coalitions that get formed.
Rent coalition.
Rent coalition is a term I use in rent in the terms of, what do you say?
House rent.
No, rent means economic rent, that is, bribes and whatever things that will happen.
Okay, rent seeking behavior.
Unholy distribution coalitions, I call them sometimes. So if you have this legislation, then someone can go and threaten them at every point of time and say that, give me the evidence that you're processing it here, you have done this, and stall the entire economic activity there. Because it's very difficult to implement it. So generally, it's taught in public policy schools that you should supply public policy which can be actually implemented and monitored. When you supply something which cannot be implemented and monitored, what happens is that unintended consequences arise from that.
Right.
So actually, so one of the things that was being in one quarter it was being lauded was
So no,
this idea.
sorry. So
on the
I
same-
forgot. So one was the technology aspect.
Right.
The other aspect was from the public policy perspective. Why do you need it? Why do you need it? Gone are the days when you think that data. If I have data at a particular place and if it is processed here, then I actually feel good that physically I have control over that thing. That is not that. We are not we are in the internet age. We are not in an age in which physical possession of the data is important, or physical access to a data is important for me to feel safe that I can take care of any kind of eventuality flowing out of that data.
So there are two reasons, at least two or more reasons that I've heard of. Data localization is being seen as a solution for many problems. One is that law enforcement feels that if the data is within our
It
jurisdiction,
has only come from law enforcement.
no, not just. So it's also come from taxation purposes.
So I said the two, the taxation also from the point of view of fraud.
Yeah.
Right. No,
So
not
because
this.
data localization in India is something which is being propagated by the banking system more than the law enforcement system. It is the Reserve Bank of India which is saying that data localization should be there,
Yes.
much more than the law enforcement agencies.
And
Well,
But
they
the law
do-
enforcement agencies have come in later to say that yes, it is why we
because
require
the
it.
MLATS process is far too complex.
But the point is,
Right.
encrypted data, encryption at different levels, data stored in clouds now. how do you localize? And even if you get that data, if you can't make use of that data in time to take care of frauds or take care of law agencies or criminal cases, what's the use of it? The intention should be more how quickly you can get that process data or information to aid your investigation into a crime or investigation into a fraud.
In fact, so one of the things I'm concerned about is the complexity for enforcement. So, for example, if there are two people who are chatting, and a chat app now doesn't necessarily have to store its data locally, but if someone mentions their caste during that chat, then that becomes sensitive personal data. If someone mentions their caste in a resume, so what probably will happen is that many companies will have to localize all their data because of the amorphous nature of the data itself, that they won't know what kind of data will pop
So that's
up
the
where.
Data Protection Authority is going to specify that.
Oh,
Yeah, it will interpret which is personal data and which is non-personal.
no, but
specific personal
sensitive personal data, 11 categories
It's-
have been given, and
Yeah,
12th
no,
will
no,
be given by the central government.
Yeah, but central government, but that is not going to, that is not a watertight kind of a thing. It can be increased and it can be decreased. It's only
Right.
illustrative.
No, but sir, my point is that if someone mentions it in the resume, and that is being stored by, let's say, Naukri.com, and if it has servers abroad, it
No,
will
so
have
I
to
am not
forcibly-
supporting this.
Yeah,
I am not
yeah.
supporting
I understand.
data localization at all, because there are complexities, and what is the purpose that you are trying to achieve is more important than how data is going to be localized. If you have the entire United States doesn't have a data protection
Yes.
law. Do we mean to say that the enforcement of laws or investigation into crimes of either white collar, blue, or the normal crimes, police crimes, are less stronger or less rigorous because of this absence of a law? No. You don't need a data protection law to safeguard you, or let's say this exemption, whatever you are saying. If you need localization only to improve your chances of success in criminal cases or fraud detection cases, then I think it is not. I don't think it just doesn't stand any scrutiny scientifically or technologically or even conceptually.
Because India has already refused to sign certain global agreements, such as the Data Free Flow with Trust Agreement at G20 last year.
At a very conceptual level, again, a company's decision to store data wherever, no government actually should come in there. Strictly speaking, no governance. The broader governance that the data should not go into the hands of criminals or terrorists, and all that will be there, but otherwise it should. But what we are trying, what this bill does, and what subsequent budget announcement, or not subsequent, even before that, the budget announcement have been done, is setting up data centers and all. We must in India also develop or make it lucrative for people like Facebook or multinationals to store their data here by providing, there's a cost for everything, so by providing infrastructure which is cheap, the IT solutions to safeguard those assets which are cheap, and transmission of the data, retrieval and transmission of data whenever required, also cheap. If we do that, I'm sure the business will come in here instead of artificially imposing this.
Right.
So the method, but initial period, maybe the signal that the government wants to give is that you have to do it here. But you must appreciate the fact that the signal that has been given in the budget is also very encouraging, in the sense
Yes.
you promote this. And that is physical storage, I'm sure at some point of time. But then physical storage of data in servers is slowly passing out. It is all in
So,
in
but the
plan.
cloud is also physically manifested
It is somewhere.
So
Yeah, you're
which
right
is
to that.
precisely
Yeah, you're right to that
point.
extent. Right to that extent. So my answer remains the same, that restrictions by forcing somebody to store data somewhere or the other should be guided more by business rather than by cost aspects rather than by legislation aspects.
Okay.
Great, sir. Thank you so much for your time. Really appreciate your speaking with us.
Thank you
Thank
so
you.
much. It was a pleasure meeting you. Thank you
sir.
so much.